All rise. The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. Welcome to your North Carolina Court of Appeals. I'm Chris Still, and I'll be the presiding judge today. To my right is Judge Allegra Collins, and to my left is Judge Julie Flood. We have one case on the oral calendar docket. It's the Utilities Commission versus the Village of Bald Head Island. And if the appellants are ready, you may proceed, and just let me know if you want to reserve any time for rebuttal. And I'll remind you, there's some matters I understand in the record that have been sealed, so just be careful about how you refer to them.
Chief Judge Dillon, Judge Collins, Judge Flood, may it please the court. I'm Sam Irvin IV of counsel with the law firm of Brooks Pierce. With me today are Marcus Trathan and Amanda Hawkins. We appear on behalf of the Village of Bald Head Island. I would like to reserve 7 minutes for rebuttal.
Okay.
Our appeal today is an attempt to obtain relief from an order entered by the North Carolina Utilities Commission approving a proposed transfer of regulated assets from Bald Head Island Transportation and Bald Head Island Limited to subsidiaries of Sharpview Capital. The transportation system that is at issue in this case is vitally important to the folks on the island, to people who visit the island, to people who work there. It's simply critical to life and work on the island. For years, the system was owned by the estate of George Mitchell, Mr. Mitchell was the developer of Bald Head Island. At a time when Mr. Mitchell was alive and developing the island, the incentives for operating the transportation system and the incentives of the owners were completely aligned. The main thing that they needed to do was get people to the island, use the island's facilities, stay there, visit. Now, we have approval of a transfer to a private equity firm, which, at least before the commission, we contended had very different incentives. There's ample basis for concern about the transfer that the commission has approved. Our argument today is that in approving this transfer, the commission committed a number of different specific legal errors. We are not attempting to get the court to revisit regulatory issues of regulatory discretion made by the commission. We're not trying to re-argue the facts. Instead, if you look at our brief, what we are trying to do is point out a number of instances in which the commission simply failed to follow obvious statutory requirements, and we'll talk about them in more detail. The first of these issues is, what is the standard that needs to be utilized in evaluating this transfer? We contend that GS 62-111A represents the controlling legal standard. And the controlling standard was definitively construed by this court in a decision which was affirmed per curiam by the Supreme Court in the Village of Pinehurst case. In the Village of Pinehurst case, this court said, quote, in evaluating a transfer application, the commission must inquire into all aspects of anticipated services or rates, and notice it's anticipated, occasioned and engendered by the proposed transfer, and then determine whether the transfer will serve the public convenience and necessity.
Now, I understand there was some discussion, I think, in your, I believe, that they might have looked at subsection E, but what did they not look at that you think?
Well, what
because they argue that they did, in any event, they did look at everything. So what did they not look at?
We contend they did not look at a number of different things. We contend, first of all, that the beginning by referring to subsection E, which is a much less strenuous standard only applicable to motor carriers, infected the remainder of the decision as well. Admittedly, the commission did state that it conducted an analysis pursuant to subsection A. And we contend that they did a number of things in the course of that analysis that constitute legal errors. For example, one of the things that they did was authorize for a period of 6 years what appear to be automatic rate increases based upon the rate of inflation. If you look at commission jurisprudence, which is cited in our brief, we point out that the commission is only entitled to raise rates in a number of specific procedural contexts: a general rate case, a complaint, a rulemaking proceeding, or when a specific statute authorizes them to do that. None of those things are present here. So we contend, for example, that the commission, by doing that, committed a legal error. It went outside
Is
its
the
statute.
commission bound by that provision? Is that
Yes.
what's the contractual agreement? So they're bound by it, so they
Yes.
can't raise rates or do anything?
Our
They're
contention-
locked for 6 years?
It's not that they can't raise rates. There are mechanisms for raising rates. The concern is you can only do it in certain procedural contexts. There's a general rate case. There's a specific statute that controls what must be considered in general rate case. There's something called a complaint proceeding that also has established procedures. There are a number of specific statutes, such as the fuel adjustment statute or a gas cost adjustment statute, that also prescribes procedures. None of those rate increases are automatic, but if you look at the commission's order, in this case, it simply says that the transferee can give notice and then raise rates up to the amount that's permitted by the inflation rate. And that's simply not something that the established law allows the
So that,
commission to
you're
authorize.
saying that agreement, they basically pre-approved future rate without any?
Yes, sir. They pre-approved them in a context that they're not authorized to pre-approve them. So that's one legal error.
Are there contexts in which they are authorized to
Oh,
pre-approve?
certainly. If the applicants came in at some point, for example, and applied for a general rate increase, then the commission has the authority to do that, but they can only do that after they conduct a detailed analysis of what's the invested plant associated with the utility, what are the utility's operating expenses, what's an appropriate return for the utility. None of that is contemplated by the commission's order in this case. And so, yes, there are proper mechanisms by which the commission can raise rates. This simply isn't one of them. Another example, to go back to Chief Judge Dillon's question, is the commission's decisions must be supported by the evidence. As, again, examples, one of the things the commission allowed the transferee to do is to permit 100% of the net income of the utility to be distributed to a parent corporation. The concern, obviously, is the utility needs to keep money too, and so it was an issue as to whether 100% was appropriate. The commission had no evidence indicating that 100% was appropriate other than the fact that the public staff and the companies in a post-hearing stipulation agreed to it. The Supreme Court said in the Carolina Utility Customers Association case in volume 348 of the NC reports, said specifically that an agreement between the utility and the public staff is not enough to support a decision.
So there would have to be specific evidence of 100%. You couldn't say
You'd have to
that
have
there was
some
evidence of 80%, correct?
We contend that there has to be some evidence that would support a decision that the commission made that this 100% factor was reasonable. There is none.
That was a Carolina, say the name of the case, Carolina, what was the name of the case?
Carolina Utility Customers Association, it's volume 348, it's 348 NC, I don't remember the page number, I can provide it if
I can
necessary,
find
cited
it.
in the brief.
I can find it, that's fine, thank you.
So that's another example. We have a situation in which we contend that the commission failed to comply with GS 62-79. Well, let me back up a second, if you please, accord another example of something that's utterly not supported by any evidence is the same automatic rate increase procedure that I talked about a minute ago. According to the commission's order, what happens there is that if the utility can raise rates by up to a stated amount without further proceedings apparently based on inflation rates, there is no evidence in this record whatsoever that inflation rates reflect the cost of providing the service that's at issue there.
Isn't part of the utility commission's role, though, to determine, they have to determine, is this buyer, how will this buyer affect rates in the future? How do they do that? They don't know what the rates will be.
Well, it's the same way the commission does when it has to make all kinds of predictive judgments, which it's required to make in the course of its work. You take evidence and you make determinations as to whether conditions are likely to be of a particular sort going forward, and then make the best decision you can. So it is to say that because there's no evidence of any actual changes, does not comply with the statute, because the statute specifically requires that you look at anticipated rates.
Well, in the process of approving a sale, a purchase, sale, a transfer like this, can it be part of the transfer that you agree to have the rates at a certain level in the future? Maybe it can't base it on inflation, but can that be part of the whole thing? Can that be part of that hearing?
It can be, but you
That
can
you could
do.
go ahead and set the rates for the next 5 years or 6 years?
If the utility consents not to change rates, yes, they can agree to that. But that's not what happened here. Well, that happened in some other instances that are not before the court in this case. In this case, however, the commission allowed an automatic increase in a context in which there was not unanimous support or agreement.
So they don't
that
have to
opposite.
raise the rates by
No.
inflation, but they can. They
Well,
have, you know,
it's a little unclear, frankly, if it please the court, because the procedure that's set out in there says up to. But that leaves, the way it's written in the commission's order, it leaves up to the utility how to do that, how much to do it. And all they appear to have to do is give notice. If you were to go through a proper rate-making procedure, you have cost evidence, you have rate of return evidence, you have a whole host of evidence.
but you're saying there's no evidence to support this particular increase by the inflation rate because there's nothing to say that
Correct.
that it's needed, or they would need to do it, or that would be fair, or whatever.
That's our argument, yes, sir.
Okay.
Another example of the type of legal error that we contend was committed here involves GS 62-79A, which is a requirement, and it's common to many different areas of the law, that the commission make findings of fact on all issues, or all material issues. And we contend that the commission simply did not do that. Again, to go back to the distribution of the distribution percentage issue, there is no finding or no explanation in the commission's order as to why they elected to approve the 100% distribution requirement, even though it was a contested issue at trial. Similarly, there is no finding in the commission's order that the inflation rate has any bearing on the cost of providing parking and barge service. And so that's a material issue relating to that rate increase provision. Even if the commission is allowed to do what it did, it's got to make findings to do that.
Is
And
Appendix
there are
A,
no such
is Appendix A part of the order? Are you considering that part of the order?
I'm sorry?
Is Appendix A part of the order that makes these statements
The Appendix A
with the
is
regulatory conditions?
regulatory conditions are conditions that the commission ordered. There are provisions in I think it's condition 4 in the conditions. There is also language in the order in one of the findings of fact that describes the process. And when I'm referring to the give notice and then change rates, that language is in one of the commission's findings.
I know that it seems that perhaps some of the findings of fact don't specifically reject the evidence from one side or the other. They simply find the evidence for one side. Are you asserting that that's not good enough?
That is a fourth area in which we contend that the commission erred. There's a long line of cases going back to a case called State X Rail Utilities Commission versus Piedmont Natural Gas Company, which I think is at 254 NC something or other. It's cited in our brief. And it says, in effect, that the commission cannot give, quote, in the language that's used in the cases, is minimal consideration to competent evidence. And there are a number of cases in which the commission was reversed by the Supreme Court for giving, quote, minimal consideration to various types of evidence. One of the arguments that we've made, and this is reflected in the confidential materials that we provided to the court, and I'm going to have to be very careful in how I describe them because I don't want Mr. Stires or Mr. Farrell to say I have violated the confidentiality agreement that I signed. But one of the issues we contend had to do with whether the commission could find that the investors in this entity were solicited and provided funds to buy it based upon a long-term hold approach or a more short-term sale approach. If you look at the January presentation, I think it's page 17 of that presentation, you will see what is described as a base case, I think, is the language that's used, and you can look at it and you can see what it says, and I'm not going to try to describe it because I'm afraid I will trespass into territory that I shouldn't trespass into. But if you look at that as the January 2022 one, then the second one we handed up was a document relating to March of 2022. Look at page 16 of that document and see what the lead approach is in that instance, and see whether the court believes that that amounts to a representation that investors were solicited to provide funds for a long-term hold or not. And you can see there is a big difference if you look in those presentations in projected net returns. If you look at the January, look at page 24 in the January 2022 presentation, you will see one number, and if you look at page 17 of the March 2022 presentation, you will see what I would contend is a significantly larger number. What were the investors asked to contribute to? What does that say about their reasons for contributing to this company?
If there's conflicting evidence from one party on short-term versus long-term hold, can the commission make a finding of fact as to one or the other?
The short answer to your question, Judge Collins, is yes. However, this issue goes to something that the commission did not address at all, which is what expectation did the investors have as compared to what statements did the management make as to what was happening. We contend those are two different things, and that the commission was required to consider, it's not required to adopt, but is required to consider the competent evidence that we presented that I tried to describe in a fairly, using the circumlocutions that I used a second ago, that they're required to do that. There are other instances in which the commission gave minimal consideration. We had substantial evidence about what was the earnings of this utility. Did it even need rate increases? That's not alluded to in the commission's order to speak of. They never addressed that issue. Another big issue was the question of whether an acquisition premium or an acquisition adjustment should be used in setting the company's rates. If you look at the record, I believe it is in document exhibit number 2, page 1814, you will see a calculation of what an acquisition premium was paid for this entity. Sharpview contended before the commission that it intended to seek an acquisition premium in setting rates. The public staff agreed that the commission didn't need to be silent on it, or could be silent on it. The commission didn't address it. They just simply said, okay, we'll put this off till later. We don't need to. How do you put it off till later if it's of the magnitude that this evidence would tend to suggest that it was? Don't you at least have to address that evidence in some respect? And they didn't do it. Now, to go back to Judge Collins, to your point, the way that you differentiate between a situation in which the commission made adequate findings or whether it engaged in minimal consideration is there are several ways, there are several tests that are set forth in the case law for determining whether minimal consideration exists or not. The commission can say they didn't consider it, and that's actually happened in some cases in the past. I think the Piedmont case originally was like that. In the later, they just were silent about it, and then subsequently in the Thornburg case, which I think is at volume 316 of the North Carolina report, the court said that you can find minimal consideration from a summary disposition. Well, we contend we have a summary disposition because over and over and over again in the instances set forth in our brief, our evidence was not addressed. The evidence that I went over from the investor presentations was not addressed. The evidence about what the rate of return that the system was actually earning was not addressed. The effect of the acquisition adjustment was not addressed. The 80-20 issue was not addressed.
Does the commission have the authority, I would assume they do, to determine what it feels is relevant, and if it determines it's not relevant, then to not address it? For example, how investors are solicited?
Well, of course, it has to be relevant, and that's why the test is important, Judge Collins. And the test, this is a totality of the circumstances test. If you look at some If you look at some utility statutes, you will find fairly specific tests. I mean, the rate-based test in GS 62133 is the reasonable original cost of property used and useful in providing service. That's a pretty specific test. This one is public convenience and necessity. It is a totality of the circumstances test. And what this court is supposed to do in reviewing a challenge to a commission order entered on the basis of a totality of the circumstances test is probably best seen in the Supreme Court's decision from 2020 in Utilities Commission versus Stein, which is the coal ash recovery case. In that case, the commission relied upon GS 62133D, which is a test that allows consideration of other facts as long as you consider all other relevant facts. And the court in that case held that the commission, in conducting its analysis under 133D, failed to consider whether the utility involved in that case had committed environmental violations that should affect cost recovery, and the court held that was a relevant consideration, but under a totality of the circumstances test, and therefore they had to consider it. They didn't consider it, and therefore the case was sent back to the commission for rehearing, and that's what we're asking for here. We're not asking that you make a decision about the merits of this case. We're asking you to send it back so the commission can make a proper decision. In this case, the totality of the circumstances requires an analysis at least of rates and service. Probably requires financing issues and other things as well. The things that we contend were given minimal consideration all go to the factors that are required to be considered under the Village of Pinehurst case. And that's why it's important that we focus on that case. One of the reasons for our concern, back to your question, Chief Judge Dillon, at the beginning about subsection E, is that's a much less strenuous test than 111A. Interestingly, our colleagues cited a 111E case when they described the 111A as a low bar. It's not a low bar. It requires a determination of whether, on the basis of all of these circumstances, the commission erred, and they did here.
Can you speak briefly about the permitting Sharpview to pledge regulated assets in support of unregulated lines of business? It's your...
All right, if I'm not understanding your question correctly, stop me and I'll try to answer what you want me to answer. Our contention is that the commission allowed the transfer of assets that the commission had asserted jurisdiction over to an unregulated affiliate. It did not address why that was reasonable. It just simply approved it. There are potential risks associated with that type of transaction.
Which asset was it?
I'm sorry?
Which asset was it?
Well, there's several assets. The way we handed up an organization chart for Sharpview that's present, and I'm not going to, again, because it's proprietary.
Go ahead and answer your question. That's fine.
But the assets that we're talking about are the barge, the parking lot, the ferry terminal on both the island and on the mainland are all to be owned by an unregulated affiliate. In the case that the commission order has been challenged by my friends over here, the decision to assert your authority over that set of assets is under review. But as of now, those are regulated assets. They've allowed them to be placed in an unregulated affiliate, and who knows what happens.
So if that affiliate is it affirmed to be regulated, then this issue goes away?
No, the commission allowed the transfer.
Okay.
And so one of the issues we contend is whether it was reasonable for them to do that. And we introduced evidence that said that it was not. That was not addressed in the commission's findings. And so that's an issue that the court, we contend that they need to be required on a remand to take care of. To finish up and yield to my colleagues, unless the court has other questions, we've laid out a series of specific challenges to the commission's order. It is our contention that unless the court finds no merit in any of those contentions, this court should remand the case to the commission. We are not asking the court to tell the commission what to do. We are asking the court to tell the commission to follow the relevant statutory authority in making its decision to correct its errors in this respect and then make a new one. We contend that that's what's legally required, and we ask the court then to reverse the commission's order and to remand this case to the commission to take another try at it. And I'll reserve my remaining time for rebuttal and yield to my friend, Mr. Stires.
We'll hear from the appellee.
May it please the court, Judge Collins, Chief Judge Dillon, Judge Flood, my name is Gray Stires. I'm with the law firm of Fox Rothschild, and it's my honor today to represent applicants Bald Head Island Limited and Bald Head Island Transportation, the current owners and intended sellers of the ferry system and transportation assets on Bald Head Island. I'm joined today by Mr. David Farrell of the law firm of Maynard Nexon, who is representing Bald Head Island Ferry Transportation, the intended purchaser of those assets. And I may refer to Bald Head Island Ferry Transportation by the name of its ultimate parent, Sharpview Capital. So yeah, I may refer to Sharpview as the buyer, Mr. Farrell's client. The relief sought today by the appellants is literally unprecedented. The appellate courts have never reversed or overturned an approval by the Utilities Commission of a utility merger or transfer in the history of jurisprudence in this state. And there's very obvious and logical reasons for that. The determination of what constitutes public convenience and necessity is ultimately a policy and factual determination. Over 75 years ago, our Supreme Court kind of stated the quote that's been repeated over and over and over again, most recently 2 years ago in the Frisian Holdings case as follows, quote, "The doctrine of convenience and necessity is, quote, a relative and elastic theory rather than an abstract or absolute rule. The facts in each case must be separately considered, and from those facts, it must be determined whether or not public convenience and necessity is satisfied." That is the seminal explanation of what the commission's role is. Now, how do they perform that?
What was that cite again? Tell me the cite.
Certainly. That was initially cited and stated by the Supreme Court in Utilities Commission versus Casey, 245, North Carolina 297 in 1957.
Well, they're not asking us to reverse. They're just asking to send it back because they're saying that there's not adequate findings.
I understand. But I do think that in the context of this, the commission has the ability and the obligation and, in fact, the necessity to draw reasonable inferences, consider circumstantial evidence, and look at the totality of all of the case. In this case, the commission conducted a 4-day hearing with expert witnesses, fact witnesses. They had reams, as you've seen in the record, of documents that were presented. And that's exactly their role as the trier of fact, is to look at that evidence, to weigh the credibility of the witnesses, their inconsistencies, their motives, and their credibility. And also to consider the recommendation of the public staff of the Utilities Commission, an independent state agency who participates in these types of proceedings, whose statutory mandate is, quote, to represent the using and consuming public, the riders of the ferry in this particular case. And the public staff is a party in this docket as well, and to consider
It
their
doesn't sound like
recommendations.
you all are disagreeing that they have to consider all of the facts. The disagreement is whether they did consider all the facts and make findings, correct?
Correct.
Okay.
And we certainly contend that you have a 52-page single-spaced, 52 separate findings of fact, a 38-page single-spaced order, and then a 7 pages, single-spaced regulatory condition, 28-page order and 7 pages of regulatory conditions in which they exhaustively tried their very best in the role of their administrative agency and the purview to review all of the evidence. And this is a type of proceeding that the commission is very accustomed to. You know, we have a CEG string site at the bottom of page 21, 22 with a number of sites, but you could go back 20, 30 years, and the commission hears and considers utility acquisitions and mergers on a regular basis. I mean, as you know from your experience here, Duke Energy has been very, over the years grown by the acquisition of companies. NCNG was first bought by Carolina Power and Light, then bought by Piedmont, and Piedmont was bought by Duke Energy. So this is something the commission knows how to do.
So my question is there any fact in here or finding of fact that talks about the long-term versus the short-term plans to hold these assets?
Yes, there is.
Okay.
Absolutely directly on point. If you will look at record page, and I'll say here I mean, you're obviously reviewing what the commission did find and did consider. So record page 852, the commission specifically even quoted and addressed the expert testimony provided by the village's expert, Mr. Lloyd, talking about the risks that he raised about this being a short-term hold. And there was conflicting evidence. And then at the third full paragraph on record page 852, it says, we have this evidence by the village, and then we have this evidence by Mr. Lee Roberts, who explained, and he goes on to state about why this would not be a short-term hold, the intention of this being long-term, the fact that this wasn't a closed-end fund, but an open fund for long-term assets. And so the commission balanced and weighed both of those sets of testimony. And then if you look at what the commission then analyzed that evidence, and at the bottom of page 854, top of 855, the commission said, the commission's regulatory oversight should be sufficient to prevent a series of short-term owners to the detriment of public interest. The public staff has reviewed SharpView's plans, projection of financial resources, and found them to be sufficient for the long-term viability of the utility. So the commission did exactly what it was supposed to do in this case, which was to consider the evidence presented on both sides and then decide, this is the reason we find that the evidence is that it could be held for long-term and that it cannot be sold without our approval to anyone in the future. And our regulatory oversight is going to address this, so we are going to decide that this is not a risk that would prevent this sale from going forward.
How about setting the rates 6-7 years in the future based on the inflation rate?
Absolutely. Let me address that, Chief Judge Dillon. So let me make 3 points in response to that question, if I may. The first is, this is an unusual context, and Chief Judge Dillon, you know this because of another case pending before this court currently right now, which is whether parking and barge are in fact subject to the Utilities Commission's regulation. That case is before this court in COA 03-1338. The commission docket was docket A41 sub 21, and that's been argued and pending. So there's an open issue as to whether parking and barge is regulated at all whatsoever. So if this court were to find in that appeal that there's no statutory jurisdiction over the parking and barge assets, then the commission would have no regulatory authority to limit rate increases of parking and barge, but for this regulatory condition. So here they were hedging their bets on what this court might decide in the A41's 21. So it was saying, even if this court were to find we don't have jurisdiction, we are going to condition this approval on limiting rate increases to no more than the rate of inflation for a 6-year period. Now, the second point I'd like to make is that the
But let's say we do hold in that case that they all are covered. So haven't the commission basically approved a rate increase without going through doing what they're supposed to be doing as far as that's concerned?
Nope, and there's a case directly on point
Okay.
that addresses this.
Okay.
And that site is in re matter of petition of Utilities, Inc., 147, North Carolina, App 182, at 194, page 194. And in that case, because there's been three cases that have appealed, but this is one of the three. In that case, the commission in a transfer proceeding under 62111A changed the tap fees on a utility. And there was an appeal that said exactly the case here, you can't change that rate outside the context of a rate case. And the Court of Appeals said at that point, yes, you can, and affirmed that transfer, noting that General Statute 62-137 provides the commission the authority to determine whether or not it's a general rate case, or whether it is a case confined to the reasonableness of a specific single rate or a small part of the rate structure. And in that case, it affirmed the commission's decision to make an adjustment of a rate in the context of a transfer proceeding. The third point I'd like to make on that is that the commission didn't create this out of whole cloth. That as the commission noted on page 849, record page 849, this precise condition was agreed to by all parties, including the appellant in this case, in 2010 in 841 sub 7. And the commission set rates in that case, which was a rate case for the ferry and tram because the parking and barge rates were not set in that rate case, but there was a condition in that case which said parking rates shall not increase for 6 years more than the rate of inflation. The same exact condition as in here was in the commission's order in 841 sub 7. So the commission had within its own set of orders a precedent for where this condition came from. They had set that in 841 sub 10 by consent of all parties. So given the uncertainty of the outcome of the appeal currently before the court in 841 sub 10, it took that condition and said, we're going, in the exercise of our discretion, to protect ratepayers by putting a limit on increases. The only thing that, and it said, we're going to start from beginning point that the rates are reasonable, and they make that finding based upon the evidence in the record, which they recite, and say, we're going to maintain that status quo for 6 years in terms of real dollars. Because obviously these purchasing power of money declines as a function of inflation over time. So if the current rates are reasonable, which is the finding that we make based upon the evidence that's recited in the record, and we're going to maintain that status quo for 6 years in real dollar terms, we're going to cap these rates so the rates cannot increase in real terms, but we will ensure that the benchmark is in real terms and not nominal term dollars. And again, that was what they did in 2010 and 841 sub 7, and they just took that order and put it in this case here. Again, there's been 3 cases. I talked about all the appeals that have occurred, and there's only been 3 cases in which there has been an appeal from a transfer order. So it's worth looking at the 3 cases arising. One is the Village of Pinehurst case that Mr. Irving cited to you. One is NRA Duke Energy, which was the appeal of the Progress Energy Duke Energy merger. And one was the NRA Utilities, Inc., which I told you was the instance where they approved a change in a rate in the context of a transfer. And it's worth looking at those other 2 cases, and particularly to the Village of Pinehurst case as it pertains to the standard of review, since you had some questions regarding the standard of review. So in this case, as you saw from the record, the commission said, we have historically and traditionally approved transfers of ferries under 62111E. And that's how we've handled them in the past. And the reason they've done that, I'm speculating perhaps here is that in the Utilities Commission, motor carriers are part of the Transportation Division, the way the Commission looks at the world. The ferry is a transportation utility, so they've always looked at under 62.111E, and that's how they have reviewed that. And so they do at least pay lip service to that, but then they go on and say in finding of fact 50, finding of fact 52, and all this, finding of fact 50, they set forth a three-pronged standard of the public convenience and necessity standard under 62.111A, and finding of fact 52, they state affirmatively that the proposed transaction is justified by the public convenience and necessity, language which is only found in 111A, and then throughout the order at numerous places, it talks about their viewing the totality of the evidence in the record. That language comes from page 854 of the order. It discusses on page 850 that it is weighing the testimony of all of the witnesses, reviewing documents presented as evidence, and considering the alternative outcomes that the decision could dictate. And then it talks about on page, for example, page 859, that the totality, again, that all the aspects looking at the transaction in its entirety, they find it's in the public convenience and necessity.
So I have a question. So in our opinion, what do we say the rule is? Is it A or E that we have to follow?
So it falls, in my personal opinion,
Sure.
it falls under A. It's public convenience and necessity. It's a three-pronged test. It's exactly the test that the commission applied.
Is that three-pronged test been adopted by the courts?
Courts, that's correct. Yes, yes, Your Honor. And we have a precedent when the commission gets it wrong and its language, and that precedent is the Village of Pinehurst case. So on this issue, you have controlling precedent as well. In the Village of Pinehurst case, the court talked about and used the language, and that was and that case, the procedural history of the Village of Pinehurst case is amazingly like the procedural history here. It's almost identical. You had a private utility that was trying to sell a water and sewer utility to another private entity and asking the commission to approve that. You had the Village of Pinehurst intervening because they wanted to purchase the utility. You had the Village of Pinehurst asserting that there was a right of first refusal, just like in this case, which was then found by the Superior Court not to be valid, as in this case. You have all these facts that are very much parallel. And then you've got the commission using the language of 111E when it looked at that water and sewer transfer. And so the court had a case in which it was the commission used the 111E motor carrier standard for a water and sewer utility. And the court in Pinehurst said, if the commission actually applied the adverse effects case of standard of 111E as the ultimate standard of the case, we would be compelled to reverse. And that's the language they used. But the court didn't stop there. They went on and looked at what the commission actually did. What analysis did the commission actually use in the Village of Pinehurst? And weighing the risk and benefits. The weighing the risk and benefits is a public convenience necessity exercise. And in the Village of Pinehurst, the court said, we're weighing the risk and benefits. They weighed the risk and benefits, considered all aspects of the anticipated service and traits, and then determined whether the transfer was justified by the public convenience and necessity, was what the commission actually did. Now, the court said there were some evidentiary gaps, and the commission could have made further inquiry. Again, they're not required to exhaust every single contention, but the commission did resolve the questions of whether the buyer could provide adequate and reliable service, and there was substantial evidence in the record to support the commission's decision to approve the transfer, and therefore the transfer was affirmed. So you've got that case as precedent, And more recently, much more recently, you've got the challenge of the Duke Energy, Progress Energy docket, that's 232 North Carolina at 573. And the contentions of the appellant in that case were very, very similar. In that case, the appellant said the commission weighed the risks and benefits incorrectly, that the commission did not give sufficient weight to the risks. The commission overweighed the benefits. And the courts went through each of those allegations of retrying what the risks and benefits were, and the Court of Appeals said, we look at the findings that the commission made. Those findings were supported by substantial evidence, and, quote, we will not second-guess the commission's determination that the merger is justified by the public convenience and necessity, close quote. So you've got three cases that are all arising from this context. It's the only three cases that I'm aware of in the last 35 years in which the same types of arguments were made in those cases that are being made in this case. Or they applied the wrong standard. Well, in the Village of Pinehurst, they said, we look at what the analysis actually was, not what the length. And, of course, in this case, the commission says it meets the 111A standard. I mean, it went even further than they did in the Village of Pinehurst. You've got a case such as the NRA Duke Energy Corp., in which the allegations that, oh, you did not weigh the risks and benefits properly, you didn't consider our evidence, and the court said, we found that there is substantial evidence.
What about the, Mr. Irvin's argument about the no finding to support the 100% distribution?
Okay. So in that regard, I make two or three observations. First, in the absence of a condition, there are no limitations on a distribution whatsoever. In theory, a utility could go out and borrow a lot of money, issue a lot of equity from a business perspective, have a lot of retained earnings, and there is no limit whatsoever on what the distribution is. So, as a matter, this is up to the business judgment of the owners and management. So to put any limitation on the distribution in any percentage, you are in fact limiting the buyer of what they would otherwise be able to legally do. So that's the first point. The second point is, the stipulation, by the public staff is considered material evidence. The village was able to, and given the opportunity to respond to that, and did respond to that. And the commission stated in finding of fact 29 on page 840, that the stipulation is the product of give and take. Well, first of all, it talks about being material evidence, and the stipulation is a product of give and take negotiations between the stipulating parties, is material evidence in this proceeding, and is entitled to appropriate weight along with the other evidence of record in this proceeding. So the stipulation itself is evidence, and as found by the commission, and there is no, I will note that that even though the appellant is saying you should have found other findings, there is no point in the brief in which the appellant says this finding is wrong. Now, as recently as 2 months ago, this court said, unless there is an allegation that a finding is incorrect, as challenged, a specific finding, that finding is binding on this court in Key versus State Bar. Here, there's no allegation that the finding that the stipulation was material evidence is not a correct finding. And then it goes on page 855 and says, these conditions are appropriate and are in compliance with the statutory provisions and should sufficiently protect consumers in this context. The conditions being the limitation on distributions.
What about that point you made? You said that because it was a finding that it was material evidence, they're bound by that.
That's correct.
But if the court, if he cited a case that the court had said that it's not, as a matter of law, it's not. So why wouldn't that be? It might be a why wouldn't that be a conclusion of law? Even though it might be mislabeled as a
Yeah.
finding.
Certainly findings of fact, that are not challenged are binding. There can be labeled findings of fact versus issues of law. And obviously, I think the point here is what are the issues of law? And we're contending that the issues that have been brought up by the appellant are in fact disagreements over the findings of fact that the commission made, that the commission made no legal.
Conclusion of law is that an agreement between the staff and the party is not binding.
Okay, so, all right, so let me,
Not
I
legally
understand your question now.
Yeah.
Thank you. I understand your question. So, the Kuka case that was cited, and that is discussed about what effect that has on page 846 and 847 of the record. At the bottom of 846, it says that the fact that fewer than all the parties have adopted a settlement does not permit the court to subject the commission's order adopting the provision of a non-unanimous stipulation to a heightened standard of review. It's not binding on the commission, certainly, and we would never contend that it is. That's a correct statement. The stipulation is not binding, but it is to be given weight as
But it
material
is,
evidence.
you're saying it is evidence.
Yes, it is evidence. It's just not
They
binding.
could make a determination.
And so the distinction between the Kuka case and this case is found at the bottom of page 847, where the commission, unlike Kuka, the commission here did not just say, well, there's a stipulation, affirmed, end of decision. It said, quote, at the bottom of page 847, the regulatory conditions, the testimony and the regulatory conditions, comma, the testimony and documents providing more context and explaining them in greater detail, comma, and the commission's conclusion as to their combined effect, considered along with all the evidence presented at the hearing on future utility rates and services, and ultimately the commission's decision that the transfer considered in light of this evidence satisfies the standards for approval that are discussed further below, standards under 111A, the public convenience necessity. So the commission said, we don't just accept the stipulation. It's evidence, we consider it. It's entered into by the public staff representing the consuming public. But it's not just the conditions, which is what the court found was incorrect in the CUCA case. But the commission expressly said, we consider all the benefits, the 14 benefits that they list on page 847 to the public, along with testimony and documents, and along with our conclusions as to their combined effect, the totality of the evidence that they undertook in issuing a 28-page, single-spaced, 52-finding order. Now, the appellant obviously wishes that there had been a different set of findings of fact. And in fact, they proposed a proposed order to the commission with a lot of the findings of fact that they would like to have been found. And that's found in the record at page 702, their proposed order. The commission chose not to find those findings of fact, but instead found other findings of fact. And the commission cannot be expected to refute every single allegation and or explain every finding that it does not adopt. And it was stated by this court in the Duke Energy proceeding case in 2014 on page 578. It's North Carolina, 232 North Carolina App at page 578. The court's role in reviewing these types of provisions under 6294B is not to determine whether there's evidence to support a position that the commission did not adopt.
I want you to just answer real quick the argument about pledging the utility assets for non-utility.
Certainly. And I've got 2 minutes, so I will try to address that as quickly as possible. 2 or 3 points I would make on that point. The first is that the appellants are absolutely correct as a legal matter, is that you cannot pledge regulatory assets to support unregulated operations. That is a matter of law, absolutely correct, that we're in complete agreement with. That is clear cut. Every utility knows that. Every utility lawyer knows that. That is black letter law. And consequently, no one would have ever considered asking for that authority No one asked for it in this case, and the commission never granted it. In page 855 of the record, which it talks about in the order, the commission's order, it says that Sharpview affirms that the debt will only be incurred consistent with the proper performance of the utility operations. The commission concludes that Sharpview is aware of its obligations in this regard, understands the import of this commitment, and is capable of fulfilling this commitment. So first, the commission found that, that you could only pledge the utility assets for utility operations. The second point I would make is that at the very first paragraph of the entire order, the transfer is described, and the assets of the transfer are described, and those assets are the utility assets, and those are in fact the only assets that the commission has authority over and could have granted permission to be indebted. And you can see that in ordering paragraph 2 at the very end of the order, which basically says, and that's on page 859, that, and if I may finish, my time is up, I might just finish this answer in the next few seconds.
You can take 1 minute to do that and wrap up.
Thank you. So the ordering paragraph 2 allows the buyer, Sharpview
Where are
Capital.
you? I'm sorry, where are you?
Ordering paragraph 2 on the record, page 859. And again, it's not explicit, it's not clear. No one ever thought that it ever would have needed to have been more clear as to what the assets are. The assets of the transfer are described in the first paragraph of the entire order, but it says pledge assets and secure indebtedness in order to finance the purchase of the assets. The assets are the utility assets, the only assets that the Utilities Commission has authority over, and the only assets that are described in the definition of transfer in the very first paragraph of the order. I would say that the regulatory condition 24 on page 864 notes that the supplemental assets, and those are the non-regulated assets, that the supplemental assets cannot be leased, sold, assigned, easement, or transferred in any way that materially impacts customers. That's black letter law. And so there's a condition that would have prevented that from occurring. And finally, we would contend that this entire issue is moot for reasons explained in our brief, that those supplemental assets, the marina slips and buildings unrelated to the utility operations, they have already been sold. They've been sold without indebtedness, sold by cash. That has been closed. No one ever envisioned that the utility would ever be pledged or credit or collateralized for that. It was beyond anyone's comprehension. And in fact, those assets have been sold, and that's issues over and done with.
Is that in the record? Do you have any, is that?
It's not in this record. We would ask the court to take judicial notice of the deeds that have been filed on public record with the Brunswick County Register of Deeds, and we have cited in our brief in a footnote and the appendix those deeds showing those assets have been sold. Thank you very much. For all these reasons, we ask that the decision of the Utilities Commission be affirmed.
Thank you. Mr. Irvin, you can take an extra minute beyond the 6 if you need it.
If it please the court, I want to begin my rebuttal by saying that a considerable amount of the argument that was presented to you by the appellees does not appear in the appellee's brief. And I would urge you to look at the brief and see that that brief makes very little or no response to the specific arguments that we have presented to the court today. And I think that is something that the court reasonably should consider. I would also like to talk about a number of the arguments that Mr. Stires made. I will try to do it in some coherent fashion, but I'm not going to promise you that I'm going to inevitably succeed in that. But let me start where he finished. With respect to the pledging of assets, none of the information that he just talked about is in this record. Does this court really want to get into business of making determinations about whether particular assets were or were not covered in transactions on the basis of its own examinations of deeds without some kind of factual determination? I would suggest that that's probably not a good idea. Our concern further remains that even though it may not have been done here, what is to prevent pledging of those assets in the future? Commission's order, it seems to us, would allow that, and I don't think that the court should uphold it for that reason alone.
But does the law prevent them from doing that? Is
The
it
law
black-letter law that you can't do it?
The law prevents them from doing it without commission authorization. If you look at the argument we made in our brief, we said again, this is another instance where this issue was raised before the commission. There were no findings, no evidence, no nothing, and the commission erred in doing that.
Did the commission authorize them
The
to?
commission said, yes, you can do that, but it never explained why. It never made any findings of fact addressing the issues that were raised with respect to this point
So
before
you're
the
saying the
commission.
commission is allowed to,
The commission has
can
the...
allow a utility to pledge utility assets to a non-utility?
Yes.
But they've got to make the findings and do all
Correct.
that. And you're saying this order allows them to do it without making?
without doing all the things we talked about earlier, yes.
Okay.
With respect to the use of stipulated information, stipulations, as I said in my opening argument, between the public staff and a utility were specifically held with respect to both the issue of return on equity and on respect to cost of service for rate-making purposes in the CUCA case to be not sufficient to support a decision of the commission. That decision is binding on this court. The commission is required to consider those stipulations. This one, I might add, was entered into even after the hearing. But it is not sufficient to support a commission decision. Controlling authority of the Supreme Court says so. With respect to the argument about, oh, well, this is just a reasonable rate increase because we did it before. For starters, none of that logic appears in the commission's order, none of it. We don't know whether the commission thought what Mr. Stires described or not because they didn't say so. Moreover, the fact that that type of rate increase might have been authorized in a prior general rate case says nothing, particularly since that case was settled and not appealed, about whether the commission had the authority to do what was done in that fully settled case or not. So what it might have done 10 years ago in a general rate case has no bearing on the legality of what was done here. If you look at the Utilities, Inc. case, I would submit to you that it does not, in fact, control this issue with respect to rate cases in a transfer proceeding. There's a specific section of the court's opinion. I would urge you to look at it. It says, first of all, the issue in question probably was not even properly before the court to begin with. Secondly, that part of the court's opinion says, in effect, that the utility consented to try that issue in that context and could not be heard to complain about the commission's decision having agreed to it. And thirdly and lastly, that everybody had noticed before the hearing began that that issue was before the commission. None of that is true here. Similarly, the idea that the outcome of this case is controlled by Village of Pinehurst, it is controlled by it in the sense that that decision sets out what the standard is. And it is true that in that case there was some confusion between 111E and 111A, but the court, in that case, clearly said 111A was the controlling statute. It also said how you were supposed to apply 111A. I read you that language in my opening argument. That's the test you're supposed to apply. It is also true that this court has not to date reversed a transfer order. I submit that that's of no consequence. If you look at the three transfer orders that the applicants mentioned, you will see that they do exactly what we have asked you to do in this case. They take the issues that are raised by the parties, analyze them on the merits, and in that instance, they decided that they had no merit. But whether those issues had no merit and ours do is a totally different question. I would also urge you not to get too concerned about the length of the order. The question is not what the length of the order is. The question is, what does the order say? And the order is silent with respect to the issues that we talked about. It does what we said. They haven't made any real response to most of them, and those are legal errors. We've set out the specific legal errors that we contend that the commission committed. And I would contend that for the most part, the appellees have simply failed to engage with those orders, those arguments at all. They failed to cite evidence that's in this record to support those arguments. They failed to describe anything except very, very general language that, as I think Judge Dillon said, is probably a conclusion of law rather than a finding to begin with, in support of them. And if you look in their brief, they cite virtually nothing. The commission has to make its decisions in a particular way. It has to comply with the legal requirements that we set out in our brief and I discussed in my opening argument. This is an important case for the village of Bald Head and for the island itself. And it's important that it be done right. We ask that you recognize the monumental consequences that this will have for the village. We ask you to look at these specific legal issues. We're not arguing the facts. We're arguing that legal errors were committed. We ask you to look at those issues, reverse the commission's order, and remand this case to the commission so that they can do a proper job of analyzing the arguments that are made by the parties in this case. Thank you for your consideration this afternoon.
Thank you all for being here and for your arguments. We will take it under consideration.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
You made the most of what you
How you hiking, buddy? It's getting long enough. Please, how you doing?